Guys, I really appreciate you all being here to really explain to contractors what the new Florida SB 76 law is for them, what they can and can't do, really just sort of plain simple text. And that's where I'm finding the problem with contractors so far is they're sort of, and roofers really making up what the law says they can and can't do. And there's a lot of misinterpretation of it all. So I just want to set the record straight, get some experts on it, get some opinions on it. So I'll let you guys take the floor a little bit.
So I guess I'll introduce everybody. I'm Pate Smith. I'm an attorney, not a Florida attorney, but I have Kelsey Boyd and Dan Sanders here. Dan in our Pensacola office and Kelsey in our Houston office. Both are Florida barred attorneys, and we're going to kind of let them expound on the law, ask some questions, and obviously have Vince field some questions here because he's run into a lot of phone calls from contractors. Also, there's some interesting PA portions of the law, public adjuster, and then also some portions of the law that affect how claims are litigated when that scenario happens. Just guys, on a quick breakdown of kind of changes in here and how this is going to affect contractors, what do you see?
Yeah, and I'll go ahead and start. There's really two Senate bills that we're looking at here in Florida. The first is Senate Bill 76, which deals primarily with the litigation side and the attorneys handling of these claims more than anything. The second one is Senate Bill 1598, which I think your viewership is probably more interested in. Adds a lot of prohibitions and restrictions on what roofers and contractors and PAs particularly can and cannot do. So I think because your viewership is largely in that area with PAs and roofers and the like, we'll probably spend more time on that unless you want to shift. The major changes really are the solicitation provision. They've really cracked down on what you can and cannot say to potential clients. The biggest one is you cannot offer anything of value to potential clients. So you can't offer gift cards or things of that nature in order to inspect.
Waiving deductibles.
Right. That's also a provision. The statute itself is, and by the way, this took effect today. It was signed into law June 11th with the effective date July 1st being today. So as of today, Florida Statute 489.147 is what the PAs and roofers in the group want to look at. And it talks about prohibited, you can hear me, talks about prohibited practices, including prohibited advertisement, which will be a big thing for a lot of the people in the area. You can't hand out certain in-person solicitations, anything that promises value for client referrals or signing, basically. So those are the biggest changes. There's some nuances that we'll cover as well, but that's sort of the global changes happening.
Okay. And so just to get into a little bit of the solicitation part, because that is their big concern, their business model of getting business completely was flipped on its head in their mind. A lot of people, what I've heard so far is, I don't know if I can do this anymore, right? They've made it so difficult. I can't talk to anybody about even roofs, and maybe I'll go sell solar and to get to doors. And there's a lot of misnomers of what they can say to a homeowner and what they can't say to a homeowner. Where the line in the sand is for that is sort of vague right now, I think, in a lot of roofers and contractors' mind.
Right, and so luckily this is one of the statutes that's a little shorter than some. We deal with hundreds of pages of laws for certain areas. This particular change is much smaller. I have it here in front of me. It's really about 2 to 3 pages worth of actual law that they need to look at. And again, that's Florida Statute 489.147. And Provision 1A, which is the very first one in that statute, talks about what is prohibited. And generally it is any written or electronic communication by a contractor that, one, encourages, instructs, or induces a consumer to contact a contractor or PA for the purposes of making a roof damage claim. Those are the ones controlled primarily with the statute. And again, it talks about no inducing via gift cards, cash, rebate, waiver of insurance deductibles, or any other value for exchange. and that's the language they use.
Dan, does this mean you can't? Dan, is this saying you also can't do the Dallas, Texas move of free ribeye roast with every new roof or flat screen TV?
Well, it depends on I guess whether you're a vegetarian or not. If you're not,
Yeah, if you value meat, then
exactly.
No.
If it's a thing of value, then you cannot give it. So the Dallas Cowboy method is out the window in Florida, at least.
So just to clarify a little bit and understand a little bit, they can talk about damage. They can't talk about a damage and make a claim and do someone into a claim, right? They can still go assess damage, offer damage inspections. It's inducing a homeowner or a client into a claim is really where the line in the sand is. Am I correct in that process?
I would say correct. So,
yeah.
So I'm a roofer. Go ahead. Sorry.
I was going to say that there is a carve-out that says they allow for the contractor to suggest that the insured call their company to see if a particular item is covered. So they are allowed to still say, talk to your insurer. Here's what we propose to do. Make sure it's covered. Talk to them and let us know. That's allowed now. But you cannot give advice on a insurance policy because arguably that's a practice of law, which is prohibited. But you can suggest they call their insurer to find out.
And
Dan, could you give like an example of that? We'll say I'm Mr. Jones and you're coming up and knocking on my door to sell a roof. Dan, sell me a roof legally in Florida.
Yeah. So the roofer can come look at the roof. They can't promise a Chick-fil-A gift card. They can't promise tickets to the Wahoos, which are our local Pensacola baseball team. You can't promise tickets to the game or anything of that nature to induce them to allow you to make a roofing claim. But once you're there, you can climb on the roof, you can look at it, you can do the normal inspection things without advising them of their policy language, and again, without inducing them with any gift or benefit. Once you do that, you can say, hey, here is what we propose to do. We're going to fix the roof. Here's what we think is happening. Call your insurer to make sure it's covered, to make sure what we're proposing will be paid for by your insurance policy. And those are all perfectly legal things with this new bill.
Are they at that point allowed to refer maybe an adjuster or an attorney as well, or they have to only refer the insurance company?
Yeah. So they can make certain recommendations in the sense of here's we know Pate Smith, great guy, adequate attorney, but great guy. Talk to him to see if he can help you out. But either way, they can put you in contact with attorneys or PAs or whatever. They just cannot give you something for doing that. And in the same vein, we cannot pay referral fees now to any contractors, to any roofers, or anything of the like.
No, and I want to add, because contractors, they're going to need to change their contracts to make sure that they're putting in the solicitation restrictions that are required, because if they're not included in the contracts with these property owners, then that gives the insured the opportunity to be able to void the contract within 10 days of executing it. So something to definitely look into.
On that note, can we get into a little bit about contracts? Because a lot of these guys were working on contingency agreements, right? Starting in a contingency agreement with the homeowner, and now is that still viable? Because the contingency means that we're talking about claims. It's viable based on what the insurance company is going to pay you. But if we can just expound a little bit more on the contract, what they should and shouldn't be doing, what they have to add, what they need to be taking out.
So with that, whenever they're entering into these contracts, it needs to be provided with like a good faith estimate as to the damages and everything that's going to be included in that pricing. They did say that it's okay if at the end of the day, the number is not the same, like the insurance company comes to a different amount, or there are some things that are altered, like the estimate doesn't have to be exactly on point, but it definitely needs to be included with the contract to say, hey, there is damages, this is what we think they are, and this is what we can probably do it for if your insurance company agrees, whatnot. But then going back to the solicitation restrictions, those definitely have to be like an actual clause in the contract, which is, I don't have the exact restrictions right in front of me from the statute,
Okay.
but it's something that they need to look into.
Gotcha. Okay.
Yeah, and Vince, a
So
couple
they
of
have to.
important things. The statute does focus on residential primarily. They are
Yeah.
absent of business claims, commercial claims. So I think that's largely unchanged from what I've read. So again, it's focused on Florida for whatever reason. The insurance companies are really attacking some of the laws to try to make it a more favorable venue for them. And so what they focus on is the insurance premium rates, which in Florida are 77% higher than they are nationwide. And part of that is they're saying there's abuse through roofers, attorneys, and PAs that are getting primarily roofs replaced that arguably shouldn't be in their eyes. And so that's what this bill is trying to crack down on, is some of the solicitation to induce that happening.
Right. They're trying to hamper the sales part of it, where if it happens, it happens. But going out and trying to find people to get new roofs, they're trying to cut roofers at the knees.
100%. It's changing for, hey, you need to file this insurance claim and we'll get you a roof for free, versus,
Yep.
hey, you have roof damage and we're a roofing company and we'd love to repair that for you.
Yeah.
Right? We'd love to replace this roof with a great new shiny roof. We're Billy's roofing company here out of Fort Lauderdale. We put on the best roofs in Fort Lauderdale. Let us take a crack at yours. That type of thing.
And then, but you got to talk to your insurance company, or here's a public adjuster or an attorney to help you with that. If you have coverage or not. I'm a roofer. I put on roofs.
Right, and Vince, that's an important distinction, is that now it's expressly prohibited that roofing contractors cannot help fill out insurance claims. They can't assist with forms or help in any way. The statute has made that clear. For PAs, an important
Public adjusters too.
Yeah, PAs can,
Yeah.
but one important change for PAs in this bill, and that's Senate Bill 1598, is that it changes the time to rescind a contract with a PA from 3 days to 10 days. So, some PAs, I don't know if they really count on that much. If you're like us, if you're not happy, move on. We're not going to hold you down. But now there's a 10-day unilateral rescission provision.
Yeah.
So and you guys can confirm this, though. If the PA spends time preparing an estimate during that time or going out to the property, they can be reimbursed for those expenses. Is that correct?
Yeah, it'd be similar to an out-of-pocket or quantum meritus type situation. I mean, you're not going to lose money if you've expended reasonable resources towards it, but you won't get that same 10% that you would expect.
Getting into the process a little bit and toot our own horn a little bit. So the PA fees, because with our system, we get an estimate and everything, and it documented, all the documented supporting documentation for a claim in a short amount of time. We really do it in about 5 business days or less, and we get that over to the insurance company and so on and so forth. So those, and this is a really personal question for me. Like you said, those costs, because I have costs on those can be reimbursed.
Yeah. So the statute's not changing your business practice primarily for PAs. You're still encouraged to handle your clients quickly, keep them happy. This provision hopefully won't come into play much. For example, in Florida, as an attorney, a client has an absolute right to a 3-day rescission on contingency fee cases. I have never once had a single client invoke that rule.
Yeah.
So, don't be dilatory. You're doing the right thing, and it'll pay in the end. But if for some reason you're fired without cause, or they decide to use that provision, you're still going to protect your costs on the back end. And that's something you can work into your contract. There's no prohibition against that.
Could a contractor use our estimate as their good faith estimate?
So in the law, obviously when laws come out, they're in writing. We have to put them into practice. There's always some gray area. So the way the law is written currently, it says that you have to do a complete detailed estimate within 60 days of signing a contract with the insured. So within 60 days, you have to have a detailed estimate. Now, how you get your detailed estimate is your business practice, however your company does it. If that's relying on others, I don't see a prohibition against that.
The question is, let's say I have a client, I'm a contractor at Billy's Roofing in Fort Lauderdale, and I go and I say this guy has a tile roof. and I go and I get an estimate for, I don't know, a repair of the tile roof versus a replacement, in an attempt to have the insurance company open up coverage on something that I know is likely discontinued. Carrier opens up coverage at a small amount, and then I wait until after the period and then submit a full replacement for, let's say, $100,000. Would that be, let's say, a violation under this law? Kelsey, do you have a thought about it?
I'm not sure that it would even. I mean, the new laws would even
Because it would be
dip
under the good
into
faith.
something like that.
Would that be a good faith estimate within the 60-day time frame? I think this is a little bit of a debate here.
Yeah, I think this is another gray area.
I mean,
Honestly,
I would
because
think that would be a supplemental,
I think
a supplemental type question, which you're allowed to supplement your detailed estimates. You know, the PA is only required to give
amend them.
right. They're only required to give what's expected at that time. So as long as they're not being fraudulent or trying to pull one over and get caught, then that wouldn't be fine. I mean, that wouldn't be a problem. So, you know, you can supplement claims. In fact, the change in the law allows for an extra year for supplemental claims.
Then I think so. I think the question is if I'm a contracting company and I use that method as a, I guess, scheme of business, would it then be a violation of this law?
So you run into a couple issues there. If it's a scheme or a standard practice, you know, I think you have some fraudulent claims, which are felonies in the state. And so I would strongly caution any listeners out there that would do that, probably against it, or else you'll be calling an attorney for a different reason. But I don't think this law doesn't change any of those previous restrictions. You know, as long as you're doing good business, using good faith estimates, the law is not really changing much on that end, to be honest.
So Dan, let me ask you this. I'm a roofer.
Right.
I go knock on Mrs. Smith's door. Mrs. Smith already has gotten paid by her insurance company of $5,000. It's a $25,000 roof, so there's a $20,000 difference. Am I able to negotiate or work on that claim for the $20,000 difference? Or could I hire a supplementing company who's not licensed to negotiate to handle that part? I know there's a lot of good supplementing companies out there. I'm just asking, are they allowed to do that in Florida? Yeah,
you would be allowed to supplement. Again, can't promise or anything to look at her roof or any of those things we've covered. But if she says, hey, you know, I got $5,000, I think there's more issues, look at my roof.
Absolutely. The roofer can supplement, not the supplementing company, right?
Yeah, the roofer could look at the roof.
This is a tough.
That's my question.
This is a tough question. Yeah, but so here's where we're kind of falling into. This is almost like a 3-part question. It's 1, can a roofer supplement? 2, can a roofer use a supplementing company to supplement? And by supplementing company, he means an unlicensed firm that's an unlicensed supplementer. So it's not a public adjusting firm. It's a company that provides roofing supplements or claim supplements. I can say that if I am a roofer, and I'm not speaking as attorney, I'm speaking like if I was a roofer, even if that was something that I thought was legal, I would not want to open myself up to the potential of having to defend and prove the legality of it because I would think it would be semi-expensive.
Because the public adjusting side of it, and again, I'm not an attorney, so my interpretation is, and it was a little vague, and that's why I asked, is it says the contractor or any representative of the contractor. And so isn't a supplementing company would be a representative of the roofing company?
At best.
It depends on how that gets into agency law and kind of how closely tied you are, and it's kind of another gray area. So it would have to be how often y'all work with them, how often you bring them in, because that
what
could
amount of
definitely
control
be,
the contractor has over the
over what they're doing.
Yeah.
Okay.
Are you
So Vince, I'll tell you
Vince,
the best thing about being an attorney
here?
The best thing about being an attorney.
I'm proposing that there's vagueness in it, and I don't want roofers saying, great, I knocked on a door, I did everything right, and they go to supplement and they hire a supplement company, and then they get hit with $10,000 fines all day, and then get audited and get hit $10,000 fines for every file they supplemented over the last year. That's what I don't want.
And so here's something that's kind of scary, and I don't know if this is fact or fiction, but I'm told the reporting agency for these are going to be the carriers.
Yep.
Yeah.
Yeah. So that's scary to me. If I'm
a roofer, yeah.
What's up, Vince?
Yeah, if I'm a roofer, I'd be terrified. I mean, FedNat already put out a letter out to, before the law even was instituted across the state, out to consumers saying, look out for these things and so on and so forth. They're going to be look out. They're going to try to make an example of people.
I mean, I would think if I'm on the carrier side, I'm probably going to do like TV ads, like, are you seeing this in your area? Let's keep premiums low.
Keep premiums
low. Probably right.
They're probably every contractor reported saves you $8 off your premium.
And then we're gonna have another Senate bill.
Yeah, they're gonna put out Crime Stopper shots of like roofing companies. $8 save on your premium with every contractor you give us. No, I wouldn't put it past them. That's an unfortunate part, right? Especially in Florida.
How are you guys gonna handle it differently at virtual?
So I mean, our system is really built. I mean, it wasn't built for this law, but it's sort of it sort of tailor-made for it. Just so happens, right, where a roofer can go sell, see damage, refer PA. Our system is built to be it's a technology you put into an app, give us the information. We handle everything virtually. So it wasn't built for it, but it sort of solves the problem where roofers can go find damage, document with our app, refer homeowner over to us, and we'll handle the whole claim process in somewhat of a partnership with that roofer to make sure the homeowner gets paid and roofer can get do the job that needs to be done for that homeowner. I have the fiduciary responsibility to the homeowner, but obviously I'm working with a roofer. The roofer got us there to help that homeowner. We're there to make sure that the homeowner gets paid to pay that roofer, and so our system is really built for it. We have a lot of Florida roofers reaching out to us to try to solve the problem for them. Be a solution for them. The guys who want to stay in line, who aren't really making up what the law does say and doesn't say, or just think I'll just change a couple of verbiage in my contract and I won't give away free gift cards, but I'll still talk claim. And there's a full gamut of different roofers out there who are very brash, where this is unconstitutional and I'm going to continue what I'm doing. We can all agree or disagree, it may be, but the law is the law right now, right? So you got to play within the rules. Unfortunately. So yeah, our system's really built to solve this problem with staying away from claim. Roofer stays in their lane, we stay in our lane doing the claim, working with attorneys as well to get things settled for the roofer and the homeowner to keep business flowing. So their model doesn't have to change too much with our system, because they can still refer, like you said, refer them over to their insurance company. One step is you refer them over to a public adjuster. We handle the whole claim process from A to Z, put together the estimate, so that we also that's why I asked about would our estimate count as a good faith estimate, because if that's the case, then they also hit that checkbox of here's your good faith estimate, and we submit to the insurance company as well, but they can use that as their good faith estimate. So they don't have to now hire an estimator to write quotes or so on and so forth. That's all handled by us.
That's awesome.
Yeah.
And I'm sure y'all have taken note of the new the claim notice statute and the changes with that too in reporting the claim in general for property owners. Did y'all know of that? It's now 2 years to file a claim or a reopened claim, and then you have 3 years for the supplemental claim. But they still haven't affected the 5-year statute of limitation for filing a lawsuit.
Yeah. So the statute of limitations, that we're definitely aware of. The thing also that I found that's a little bit vague and people are not understanding is how attorneys' fees work, how the notice to litigate, the notice to litigate, and all that. And so it's interesting to me. It may not be so interesting to roofers, but again, I think it's a little bit hard to understand. And then if they do make an offer, you get a percentage of it, and you got to get over it, and then you get your attorney's fees. So sort of maybe Dan or Kelsey, Just let's explain that a little bit so both public adjusters but also roofers can understand it, what it means to their homeowners and all of our clients.
Right. Put simply,
Is this the 50% attorney fee?
yeah, there's really a sliding scale now. Historically, there's been a one-way attorney fee provision in Florida, inuring to the benefit of us as the plaintiffs in these cases. And the insurance companies, again, have pushed back for years and finally got some traction with this. And this goes back to the Senate Bill 76 as opposed to the other one we've been talking about. And so the major changes in that is, one, a pre-suit written notice as of today we have to do before filing suit. At least 10 days before filing a lawsuit, we have to give a written notice with certain terms in it to give the insurance a chance to settle. If they settle within that time, we cannot file a suit. Basically we're done. If they don't, we can initiate suit like we used to, but there is some extra requirements for attorney's fees. And basically the terms that we are now concerned with are, one, our pre-suit settlement demand value. That's how much we tell the insurance company to pay us before we file. The other number we look at is the settlement offer pre-suit, and that's the insurance company's offer before we file. Those two numbers are used to calculate a disputed amount, and that's the statutory term they use. That number is then what we look at for litigation. If we're able to beat that amount, then we get all the attorney's fees and everything is beautiful. If for some reason we don't, then we look at the amount we received, or amount obtained, minus the pre-suit offer, and that's how we determine attorney's fees. So there's some math involved, some algorithms now.
Yeah, I feel like we need that whiteboard.
Yeah, I think Pate has a big whiteboard back there that he could probably use.
Yeah.
I got extras. I'm ready to jot, boys. Let's go.
But stated simply, Vince, they're encouraging pre-suit settlements by giving extra benefits to the insurance companies, making us attorneys jump through more hoops in order to get those one-way attorney fee provisions we like.
Do you think that will lead to faster settlements or more amicable settlements without going to litigation?
Do you want the political answer or what I think? And
They do have like a time frame.
yeah, what I think
I know they have a time frame.
It's not
But
going
like
to change.
pushing things to appraisal or mediation outside of litigation. Do you think that will be a big push for insurance companies to keep it out of litigation?
Vince, I don't think this will change a damn thing, if I'm being honest, except delaying litigation by maybe 14 to 21 days if they invoke the right to reinspect the property, which they can now do. I think you'll still get.
But if they do choose,
Go ahead, Kelsey.
if they do choose the ADR or pushing to appraisal, they do have to complete that within 90 days. So I do think it is giving us more of an opportunity to get those things resolved quicker. So it's like, okay, if the ADR or the appraisal process doesn't work, then, and if it's not completed within those 90 days, you can file suit. So that's also beneficial because it keeps them on their toes and they have to get this going and get it done.
Right.
And it's not, they can't drag it out as they most of the time do. So, I mean, I don't know. It could go both ways.
And I don't think the pre-suit notice of 10 days is that big of a deal unless you're absolutely knocking on an SOL or other time frame issue. Because typically in Florida, you're going to send a civil use notice anyway.
It's going to toll
Right.
away.
It'll
toll the statute.
But also,
by the way.
I heard in the statute, and I haven't read it,
Yeah.
but I heard that the statute also says you have to inform the department. It doesn't say what department; it just says the department.
It's the
What department that is.
Financial services.
Yeah,
We can all assume it's the Department of Financial Services, but it doesn't say. But I mean, I'm sure you sued citizens many times, and that's who you have to serve when you're suing citizens, correct? And I'm sure that I don't imagine that if every notice of litigation is going to go to the department, that they're going to be getting these things in 5 business days, right? The 10 business days, so 2 weeks, that they're going to be able to get these notices to insurance companies in a timely manner where the insurance company is going to respond in that 14-day period.
Right. So the way.
Yeah, because
Right?
if they don't respond, well, if they don't respond 10 days, you can, right, Dan? You can file suit after the filing.
That's correct. It's got to be 10 days.
Yeah,
so really, it's 11 days.
Business days, correct?
It's 10, but the Florida Judicial Rules of Administration count for calculating days. So the day submitted does not count. and the last day, if it falls on a Sunday or holiday, doesn't count, weekend or holiday. So really, you'll get 12 days sometimes, or 13 even.
But it's business days, correct?
No, it's a straight calculation. So it's 10 days,
Oh,
not
really?
counting the day filed, and
I think it's business.
it's all electronic.
I think it's
as well.
business days.
So each insurance, it's going to be, unless the statute has got a provision I haven't seen, which I don't think it does, but it may. It's typically 10 straight days, but doesn't count the day of filing, and the last day cannot be on a weekend or a holiday. It extends to the next business day at that point.
Gotcha.
And so what happens, just like with the civil remedy notice in Florida, you file it electronically on a form approved by the department, which is the Department of Financial Services. They automatically electronically send it to the insurer, and they have to register. The insurers have to register an email address to receive these. So in theory, when we hit send, the department will hit send to the insurance company, and that starts their 10 days. If for some reason they don't get it, the insurance company.
Dan, I don't think Saturdays count.
Say that again.
Did you hear me?
Yeah, is there
I don't think Saturdays count.
is there terms in the new statute that
Yeah, it's in the statute.
say? Okay, well,
Yeah,
I
it's
apologize.
10 business days.
Okay, because typically it's 10
Yeah.
straight counting with the additional days.
And then any reinspection.
Okay, yeah, if that term's in there, I must have overlooked that.
Yeah,
I
and then any
apologize.
reinspection.
Say that again, Kelsey.
It's okay. Just so we all have it clear. And
Yeah, no, that's
everybody's
extremely
on the-
important that we do have our.
I said, just so everybody's clear and everybody's.
Yeah, no, that is important, because these timing issues do matter. Because if we file too early, they will kick it from the court, dismiss it without prejudice, and we have to go through all the steps again. So timing is important. So either way, the notice will be automatically sent to the insurer, though, and that starts the time, which I guess excludes weekends. And Kelsey, are holidays excluded as well in that? Does it say?
That I am not sure of.
I would
I think it
say
just said-
yes.
I would
because
think
it's-
so.
It specifies
Business.
business days.
Yeah.
Yeah. So it's probably holidays are probably not a business day. So
Yeah, and I do see now it's 3A of that statute.
Yeah,
so
correct.
that's 627.70152 3A. So I do see that now.
all right, gotcha. So that's I better understand it. I appreciate that, because for us, like on our side, when we're getting to that point, explaining to a homeowner what their options are, how it works, and everything, definitely need to understand that. So I really appreciate that side. So back to the roofer side a little bit, just to sort of wrap up. Also, they don't have to change what they're doing a lot. In essence, what we all, I think I've learned here today, and what I sort of knew already, is they don't have to change much. They got to tweak their sales pitch. If they're actually good sales guys, like Pate said, they should be able to do it, tweak a little bit, and their model isn't flipped upside down and they're going out of business. The world isn't on fire.
I want to say, Vince,
I'm
if
listening to
any of your listeners or people have specific questions, as Pate mentioned, we're happy to answer all of them, whether in person we can do it or via email. I have no problem giving my email out to anybody of your listeners that will use it responsibly.
absolutely.
Appreciate it.
So
I'll let my
mine
mom
is-
know.
Yeah, we'll give it to you, and you can share it. And again, we'll answer any and all specific law questions they have, and hopefully we can all get this right without disrupting business for anybody.
Yeah, I think that's really the concern of roofers, is how this disrupts them. Does it, and what level it disrupts them?
Right.
I have guys that literally switched to going to retail and selling solar because it terrified them. So, and I understand, but
I like the idea. I like having a retail background. I think guys that sell retail in the past will still crush.
yeah, because it's an actual sale.
It's just changing their little.
Right.
Yeah, they
It's
actually
a
have
very
to sell
slight
it.
adjustment or
Yeah,
no
it's a-
adjustment for them.
Yeah, it's just
And with our system, it's plug and play. I mean, really and truly, like
I've
they just stay away from the word claim. That you can make a claim and do somebody into a claim. Refer it over to us, and our system will handle everything. They don't have to really change much at all, and we take care of their good faith estimate portion as well. So on a plug and play, I mean, we have some larger players in Florida reaching out to us to try to solve this problem for them, because they're worried about it. They're worried about it. They don't want to change their model. They've built their business on this model, and so if we can solve it for them, it's a great situation for them. So.
And Vince, I think this law may help you because
Vince, did you tell them that if
I was going to say,
Go
I
ahead,
think
Dan.
Vince, this may help you because you're ahead of it. You're learning it before you needed to. This law just took effect today, and you already have 3 attorneys on here talking about it. So it sounds like your system is probably going to help people before others will. So you may benefit from this law change, to be honest.
Oh no, I in Florida, 100%. Do you think other states will adopt this?
Florida is very protective because of the elderly community in the southern part of the state. I think it won't be as broad of a change in other states. Florida is just very restrictive because of that aging population. So I don't see other changes as broad in other states.
Okay. Do you think like the more of the storms?
I'd agree with you.
The storm cities, the storm states, more like the Texas, Louisiana, things like that, won't adopt it. Pate, I feel, has an opinion here because he's like,
Texas did some changes in 2017.
Yeah.
That helped improve the whole system, I think, a little bit.
Texas had the Hell Bill, which that also kicked in the 542A notice, didn't it?
I believe so, yeah.
Yeah, and so Texas has the Hell Bill. So a portion of the Florida bill, if I'm correct, was crafted after the Texas bill. Is what I'm told. So yeah, I mean Texas kind of already has it. I think you're seeing a little Colorado reform talks. Nebraska had the adoption of LB 743, which put some constraints on insurance consulting, public adjusting, and provided for some UPL in those states. So these adoptions have been happening in other states, just not as aggressively. If you saw recently, Georgia just went through a legislative session, and this was harshly fought as well. So sweeping changes are happening. And if you're a contractor out there, I think it's important to have guys like Vince and his team, us, in your Rolodex, because, we're not going to be perfect for every scenario, but there's going to be scenarios where your clients may need us, and we want to be there for that. And I always say, if the virtual PA can't get it paid, add the TE to the end and we're ready to roll.
boom,
How good is that? I just came up with that off the cuff.
boom. I like it. That sounds like a merger. Going on there, Pete.
I mean, let's make a YouTube video, a commercial. This is James. He's my boss, so everybody kind of calm down.
Yeah.
We're looking at quiet. No, I think it might even be beneficial for like a few months down the road, like touching base again, just to see how all of this gets implemented and how it affects like the day-to-day process of
how they're
how
actually going to start to enforce it, how insurance companies are going to react to this. Yeah, it's definitely. I've been in processing claims in Florida for 12 years now, so I've seen the ebbs and flows and what they tried to do. Citizens getting rid of PAs basically completely, creating the insurance litigation monster that they've created. Basically, insurance created this, in my opinion. You got rid of PAs with Citizens. PAs went. What?
Quick question for you. Are you guys running into any of the policies that have the public adjusting exclusion where it specifically says, in light of the reduction in premium cost, this policyholder is not allowed to hire a public adjuster in terms of a property damage claim under this policy?
Yeah, I've had a couple. They're not widespread, but I've had. Avatar, I know have a couple of the really small.
How are those being handled?
Basically, Avatar, for example, I'll just use an example. Avatar, their desk adjusters are attorneys. You call, you're speaking to basically to a lawyer. They're very tiny. They have, I think, maybe like 20,000 policies or 30,000 policies. They're a small company. They're not that big, but I'm sure as litigators, Dan, I don't know if you ever had litigation with Avatar. I can't stand them. A lot of the times I'll walk away because unless it's really, really worth it, it's not worth it for me, to be quite honest with you.
Right.
They're just they dig in their heels from hello.
Yeah, the
I haven't
one
even
thing
told you I
was,
want to make a claim
When
yet.
you submit
yeah, the one thing is,
when you submit an LOR, what do they submit?
They send us a letter that our client has agreed not to use a public adjuster. We're not honoring your letter of representation. Yada 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 yada. I mean, Dan, have you had run-ins with Avatar?
yeah, they're like State Farm. They're adversarial from the start. There's a couple other ones we won't name, but they like to push because most people will fold when they do, and they know that. 90% of people will settle for what they offer pre-suit, and they know that globally speaking, that's in their benefit. So the problem is they run up against people like us, and James, being ex-military, one of our named partners, is always open for a fight, and so are the rest of the attorneys in the firm. So if they push, we're happy to push back, and they're not going to intimidate us or anybody in our firm.
Oh yeah, no, it's not so much intimidation. It's like, is the juice worth the squeeze, right?
Right.
If this lady's claim, I may take on someone's claim that's $15,000, who's one company, but then if it's Avatar and there's a little other details to the claim, and it's like, is it really worth this? Not just for me, is it worth for the homeowner? Like,
Right, and that's
homeowner,
what-
do you know what you're about to get yourself
I've
into?
That's what it comes down to. It comes down to the
Yeah,
client or the homeowner. If they're ready for the fight and understand what's going into
Right.
it, the cost-benefit analysis, that, Vince, I feel like you're like we are. You're willing to fight if they're willing to be in it with you. And again, it comes
Oh,
down
I'm
to
Jewish.
the
I
client.
argue about everything. So
I love it.
So yeah, I just like that. That's where I come to with those kind of companies. Maybe you can't say the names. I can, like People's Trust and Florida Peninsula and those ones. Yeah, those ones. I just really lay it out to the client. It's really the client's decision at that point. I lay out the facts. Here's what it's going to be. I'm all down for it, but this is what you're going to have to do to get there. Right? Here's the finish line. Here's the steps we're going to have to take to get there. I'm 99.9% positive that's what we're going to have to do. Like for People's Trust, for example, you may be sued by your insurance company. Are you ready for that? Right? If you're not, then maybe this isn't the right move for you.
It's so good that you're upfront with that stuff, though.
Well,
That helps us in the back of it as
Oh,
well.
yeah, otherwise, I'm wasting my time, their time, everyone's time, and they tell me I didn't tell them that they be, I'm getting sued by insurance.
Basically, if you're a public adjuster in Florida selling,
I'm sorry, what? It broke up.
Oh. Yeah, I was saying basically if you're a public adjuster in Florida and you're selling how easy of a ride this claim's going to be, might want to rethink your pitch.
Yeah, it's definitely not, because I've tried that. I've been there, done that, and ate dirt. So walked away from fees. So I learned my lesson early on at a young age, and so now I'll just put it out on the table. And if the homeowner wants to eat, then I'm ready for war. If they're not ready to eat, then I ain't going to that restaurant. So I really appreciate you guys jumping on here, really explaining out, laying it out for everyone. I think that it really cleared the air for me, but also for roofers in a clear understanding of what they can and can't do.